firm of Arnold & Porter, and an adjunct professor at Georgetown Law from 2001 to 2008. He served as legislation counsel to the Nonpartisan Joint Committee of Taxation in the U.S. Congress. And being a fan of his scholarship, we're very lucky to have him here today, and we'll let him take it away. Thanks.
Thank you. Thank you very much, Eric, for that splendid introduction. Too much about what my accomplishments may or may not be, but it's always, it's really, really great to be here, and I really appreciate the opportunity. So I first learned of the legacy of Norm Sugarman when I was a staffer at the Joint Committee on Taxation, and it was very hard to do anything in the world of nonprofits without hearing his name. He was constantly there behind the scenes. The old hands at Joint Tax would say, oh, Norm Sugarman, he's responsible for this rule, or he's the reason we have this regulation. And it's you can tell that the impact he had on the law of tax exempts and nonprofits was really significant. So it's a real privilege to be able to give a lecture in his name. So thank you for the opportunity. So the title of my talk is Emergent Threats to the Charitable Sector. And I want to begin by highlighting 5 recent news items that would have seemed to me like fake news if they had happened a year ago. So one, in February, the Department of Education sent out a memo to all schools nationwide, K through 12, and including higher education, public and private, attacking diversity, equity, and inclusion initiatives without defining DEI and threatening private schools with adverse action if they did not comply with the memo's vague directives. The memo seemed designed to have a chilling effect on every institution of learning in the country. Second, President Trump threatened Harvard University with revocation of its tax-exempt status because he said Harvard does not serve or provide a public benefit. Third, a private interest group complained to the IRS about the Gates Foundation's minority scholarship program. In response, the Gates Foundation, which is the nation's richest, changed its program. 4, the administration announced drastic cuts in NIH grants, which, if implemented, would result in billions of dollars of lost research funding. And 5th, the administration pursued and continues to pursue billions of dollars of cuts to select universities, mostly in blue states, of higher education. Each of these news items, and there are many more, speak to a new approach to charitable associations coming from both public and private actors that essentially attack private missions and operations, leading me and others to believe that we are on the cusp of a new era of law enforcement against civil society organizations and the weaponization of tax-exempt status. So how did we get here? Well, before I talk about some of these present-day threats and challenges, I want first to talk about American civil society more generally and recent challenges that predate this administration. So first, giving you a little bit of a roadmap here, I'll talk about the strengths of our legal system as it relates to private associations and how the law fosters independence and pluralism in civil society, which has made the charitable sector a vibrant source of American strength over the course of our history. Next, I'll talk about the status quo as of the beginning of this year and weaknesses that we're already developing in the legal structure. Then I'll discuss emerging threats to nonprofits that are present in the current political environment. And finally, I'll lay out some thoughts on how to respond to some of these threats. So first of all, consider our civil society. The U.S. independent sector is large and diverse, with well over 1.9 million nonprofit organizations, 1.6 million of those are charities. Nonprofits account for over 12.7 million jobs and 5% or more of the nation's GDP. Programmatically, nonprofits deliver education at all levels, provide most of the nation's health care, house religion, deliver vital social services in communities, conduct life-saving research, and advocate for policy change. American civil society is the biggest of big tents. And that we have such a large and dynamic nonprofit sector is not an accident. There are key systemic supports that provide what I will call here a four-legged stool upon which our version of civil society rests. The first leg of the stool is the general associational law. It is practically obligatory at this point to reference de Tocqueville, who famously observed during his visit to America in the early 19th century that Americans love to form groups. And I guess we do. Big groups, little groups, mundane, boring groups, controversial groups, lots of associating. De Tocqueville surely was correct, but this group formation happens not only because Americans are social creatures, but because they are allowed to form groups that are independent from state control. An important early case in 1819, the trustees of Dartmouth College versus Woodward, established the principle of associational independence from the state. There, in a decision that has some echoes today, the Supreme Court protected Dartmouth College from a hostile takeover by New Hampshire, ruling that the state lacked power to override the private contractual association that made the college. Another important decision in 1844, Vidal versus Girard's executors, established the legitimacy of charitable trusts, allowing them to form without statutory authority, enforceable by courts through the exercise of common law equity powers. From there, it took a little while, but by the early 20th century, private associations were on a strong legal footing. Today, of course, it is easy to associate and have a legal perpetual existence. State nonprofit corporation statutes require just a few documents and a filing fee. And in most states, a nonprofit purpose is anything you want it to be, so long as it is lawful. In short, the legal system strongly supports private associations of all shapes and sizes. So that's the first leg of our civil society stool. The second leg is related to the first, and that's associational values that are protected by the First Amendment. Explicit First Amendment protection for association may be more recent than you think, as the associational right wasn't teased out until teased out of the First Amendment until 1958's decision of NAACP versus Alabama. Since then, First Amendment case law has consistently affirmed key values relating to association. These include pluralism and respect for differences, independence from government orthodoxy and the allowance of dissent, the fostering of community and identity, and innovation of thought and action. These are constitutional civic values and help make us who we are as a society. That's our second leg of the stool. The third leg of the civil society stool is a political consensus. Now, over several decades, both political parties, in different ways, have supported the charitable sector. In one model, more on the left side of the political spectrum, nonprofits are an extension of government, maybe even big government. So nonprofits are there to do more work in society, with the government's help, more of a public-private partnership. In another model, more associated with the political right, nonprofits are a preferred alternative to government. Under this view, private philanthropy will be better at solving social problems than the government will, George W. Bush's faith-based initiative and his father's 1,000 points of light are good examples of that model. Either way, on the left or the right, there was some, even if sometimes a grudging, consensus that mission-driven organizations have an important and legitimate role to play in society. And as a part of that political consensus, funding for many causes and nonprofits carries over from administration to administration. There are always hot-button issues for purposes of federal funding, like abortion, for example, but continuity is more the norm than the exception. And critical to this political consensus, I believe, is the rule of charity tax law, now known as the Johnson Amendment, that prohibits charities from engaging in partisan politics. This rule, although much beleaguered, helps to maintain trust and political consensus that nonprofits are broadly aimed at providing public benefit based on mission and not partisanship. Finally, the fourth leg of the stool is the federal government's tangible support for the private nonprofit sector in the form of both direct funding and through tax benefits. It's important to distinguish those two. Direct funding, of course, occurs through appropriations and federal grants and is vital for many nonprofits. And as we're learning, it inherently carries risks. Reliance on federal grants reduces independence to varying degrees, whether it's an existential risk because government is the main source of funding, or whether it is through program leverage the government can exert as a condition of the funding. Direct funding is also inherently political because it requires political consensus to continue, and the nurturing of ongoing lobbying and other relationships between nonprofits and the government on a bipartisan basis. Indirect funding through tax benefits is a categorically different sort of federal support, and the one I'm more focused on in my work. I often ask my students what the tax benefits are for. What does the federal government subsidize or support with tax exemption, the charitable deduction, and numerous other benefits tied to charitable status? I think the best answer is that the tax benefits subsidize independent, mission-driven organizations and the pluralism that goes with it. In other words, the charitable tax benefits are not a subsidy for religion or healthcare or education or advocacy work. There is no specific public benefit being subsidized, nor are private charities required to do the work government otherwise would do. Yes, charities fill gaps and often perform functions that might otherwise fall to the government, but that is not a requirement of exemption. In short, the tax benefits promote a diverse civil society. That is a main part of the public benefit. So we might call the tax benefits a pluralism subsidy, which has been largely successful for two reasons. One is that Treasury regulations in 1959 embraced the definition of charity in the legal sense, meaning that charity is not limited to relief of the poor or the needy, but is much broader and allowed to evolve with society. Second, and related, it is safe to say that the IRS regulates entry into 501c3 with a very light touch. The gate is open pretty wide, and once in, charities operate freely, by which I mean there is no micromanagement of activities or outcome measurement. Instead, the law requires just that the organization adhere to some basic negative rules. No private inurement, no private benefit, no substantial lobbying, no electioneering, and a lawful purpose that is not contrary to fundamental public policy. Critical to all of this is that the government may not, and generally does not, engage in viewpoint discrimination or political bias in determining which groups are eligible for tax benefits. A neutral posture made easier by the Johnson Amendment. So to sum up then, The four legs of the stool that support our civil society are general associational law, First Amendment values, a political consensus that nonprofits are a force for good, and regulatory support for pluralism. As a result, we enjoy a diverse, innovative, and sometimes noisy sector that strengthens communities and freedom of association, and that provides vital services that are both an alternative to as well as a supplement for government. So with the pluralistic charitable sector established as a necessary predicate, I next want to talk about the state of that model before the current administration took office, and then I'll turn to more recent events. So for most of my career, I've been in the thick of nonprofit tax policy, first at a law firm in DC, then for 7 years on Capitol Hill, and since 2008 as a law professor writing about tax law and policy as it affects nonprofits. As I look back over this quarter century, I would say that we've seen the collapse of the IRS as a regulator of charities and legislative neglect on the charitable deduction. As I'll discuss, this has weakened the federal support leg of the stool, making the sector open to politicization and mistrust, less pluralistic, more elite donor-centric, and more vulnerable to direct attacks on its funding and independence. This in turn feeds a loss of political consensus, bringing the stool to a point of collapse. So taking regulatory failure first, it may be unpopular to say, but charities need a reliable regulator to set standards and provide guidance. It's a bit of a Goldilocks problem. An overbearing regulator is stifling and undermines independence, but a weak regulator allows for the erosion of trust and popular support and understanding. Something in between, a regulator to police bad actors and provide necessary guidance, maintains credibility. Unfortunately, however, since the Citizens United decision in 2010 and its political aftermath, we have had a weak regulator in the IRS and low to no enforcement of the law. This is having a host of ill effects. So in Citizens United, the Supreme Court basically created a new category of lawful corporate speech, so-called independent expenditures, or in plainer terms, electioneering conducted independently of any campaign or candidate. Although the connection may not seem obvious at first, the decision placed a lot of pressure on the tax law and the IRS. Suddenly, after Citizens United, non-charitable nonprofits could engage in a lot more political speech than before. In fact, with the campaign finance limit declared unconstitutional, the only limits to political speech by nonprofits were tax law limits written in a different era. This, combined with favorable non-disclosure rules, made nonprofit organizations, and particularly 501c4s, or social welfare organizations, very attractive vehicles for political speech. The result was a slew of new grassroots groups, many related to the Tea Party, applying for 501c4 status. This proved to be an administrative nightmare for the IRS, as the agency had to determine whether these Tea Party groups had too much political activity for them to qualify as a C4, or whether they were better thought of as political organizations recognized under another part of the tax code known as 527, which also has tougher disclosure rules. The irony is that the choice for putting Tea Party groups into C4 or 527 was not really a tax issue at all. Both types of groups are basically tax exempt, but the IRS's mishandling of the situation led to a major political firestorm. because many of the affected groups were on the right politically, their defenders in Congress declared it was all a targeting witch hunt for conservative views and groups, likening the situation to a Nixon enemies list. The IRS stood accused of using its administrative discretion to attack grassroots organizations for their viewpoints. This so-called targeting scandal strongly shaped attitudes on the political right and helps to explain, I think, the moment we are now in. The story took on a life of its own and created a narrative that the Obama administration IRS was out to get the political right. To be clear, I don't think that's at all fair to what happened. It was a management problem, not a political problem, and not political targeting. And Congress actually deserves a lot of the blame here, but the result has been to weaken the IRS when it comes to nonprofits. Ever since, the most significant IRS initiative has been the introduction of a streamlined check-the-box form for small charities known as the 1023-EZ to get approval for charitable status with essentially no IRS review. An already low examination rate has dwindled to near zero, leaving the overall correct impression that there is little risk to non-compliance. This in turn impacts self-regulation, as bad actors have less reason to fear consequences, and even erstwhile good actors may be more prone to mission drift or private benefit. Trust in nonprofits has declined in recent years, due in part, I believe, to the regulatory black hole we are now in. So the regulatory vacuum has been ongoing and coincides with another adverse development, namely the failure of charitable deduction policy. There are two broad problems here. The first is the shrinkage of the charitable deduction. Tax law changes in 2017 shifted millions of taxpayers from itemizing their deductions to taking the standard deduction instead. As a result, overnight, the percentage of taxpayers eligible to take the charitable deduction dropped from about 25% of the taxpaying population to under 10%. Thus, it is no accident that since 2017, the number of households giving to charity has declined significantly, and more gifts are coming from mega donors whose gifts make up an increasing share of all gifts. I think this is corrosive to the sector and undermines the main justification for the charitable deduction, which is to foster pluralism and private choice. It means that the government incentivizes the contributions of only the wealthiest in society, subsidizing their cultural causes and policy priorities. When charitable causes reflect elite values, the people disengage from the public-facing civic sector, opening the door to conspiracy thinking and distrust. In other words, the pluralistic values that support the charitable deduction and civil society falter. The second problem of charitable deduction policy is the unfettered rise of intermediaries in charitable giving. An intermediary is a charity like a private foundation or a donor-advised fund that holds on to funds before granting them out to benefit a cause. Over the last several decades, intermediaries have taken more and more of the charitable giving pie. In the early 1990s, about 5% of individual gifts went through an intermediary, typically a private foundation, with 95% of giving going directly to working or operating charities. I start with the 1990s because that was the year when the modern commercially affiliated DAF was born, Fidelity and the Vanguard Charitable Gift Fund. By 2010, 15.7% of gifts went to intermediaries, and in 2023, 35% of individual gifts goes through an intermediary. In other words, more than 1 out of every $3 given to charity by an individual now stops with an intermediary. One think tank projects that intermediaries could account for half of all individual gifts by 2028, yet no working charity benefits from a gift to an intermediary until the money comes out. So why does this matter? One, the funding stream for charities is congested. Instead of near 100% of current donations going directly to charity, we're down to 65%. Thus, while giving as a percentage of disposable personal income has not increased, the flow of funds to charity is bottled up and remains under the effective control of donors. This increases the power of donors and makes less money immediately available for use in a charitable program. The second problem, I think, is that DAFs in particular undermine the point of the charitable deduction, which is to encourage direct giving. There is a delicate balance in charitable tax policy between advancing the interests of donors and the work of charities. With the rise of DAFs, I think the balance has tilted too far to favoring donor interests. The trend, combined with fewer itemizers, more clearly makes the deduction a planning tool for the wealthy and not about altruism or sacrifice. I do wonder what Norm Sugarman would have made of it. He was a strong champion for community foundations and their DAFs, yet his vision is very different from what has occurred. The community foundation model was like establishing an endowment for community needs similar to a university, and it's a model I support. But modern commercially affiliated DAFs are not mission-driven. There is a disconnect from the donation and the mission, turning regular donors into philanthropists. Unfortunately, in my view, the charitable deduction is fast becoming an incentive not to give, but just to earmark funds for future charitable use and not to any specific charity or mission. This harms operating charities by delaying their use of and access to charitable funds. In short, at the end of 2024, I would have said that the charitable sector was under stress from the combined forces of an ineffective regulator, an inattentive Congress, and a charitable giving incentive that favors the choices of the wealthiest in society and even allows, through DAFs, an indefinite delay in actually completing a charitable gift, further tilting giving policy away from charities in favor of donors. Yet, still, I also would have said that these very real challenges fit within the norms of debates about charitable tax policy and regulation, and I was hopeful that legislative and policy fixes would emerge over time. I am, however, a little less hopeful today. We are in the midst of a new series of challenges to the neutrality of the charitable sector that threaten the old political consensus. Instead of a viewpoint-neutral approach to tax exemption, we are seeing an effort to screen groups for ideological commitment to the policy priorities of the current administration and the weaponization of tax-exempt status. The new approach has several tools in the toolkit: harsh rhetoric, funding cuts, threats to cut funding or to investigate, and the writing of new rules that allow for the targeting of charities. Starting with the rhetoric. In his first days in office, President Trump said that nonprofits are thugs and sleazebags. Elon Musk said that nonprofits make money off the homeless. The neutral term nonprofit is replaced with the more sinister acronym NGO. It appears increasingly that nonprofits as a class are viewed by this administration as part of the deep state, if not a liberal conspiracy, or as Marjorie Taylor Greene put it in a recent hearing, as the fifth branch of government. The danger to nonprofit organizations from this sort of damaging, disparaging rhetoric is very real, as mission-based, community-driven organizations depend to a great degree on the trust of their communities. If nonprofits and philanthropy are just another scam designed to take your money so that others can profit, either by siphoning away taxpayer dollars with government grants that fund sinister NGOs, or by subsidizing charitable gifts that benefit billionaires, not only will nonprofits lose, but so will the communities they serve. Unfortunately, as I suggested already, the regulatory and policy failures preceding this administration have made the nonprofit sector ripe for this harmful narrative, because there is a degree of truth to the claim that philanthropy today inordinately serves the interests of big elite donors. Beyond the rhetoric, what concerns me in this moment are the concrete steps the administration is taking that can cause lasting harm to sector independence and political neutrality. While there are many examples of hostility to certain groups and purposes, I want to focus on areas where the administration leverages federal power to coerce or co-opt private organizations to curtail their missions and activities. And not to be misunderstood, it is one thing for the executive branch to disagree with an organization or to fund different priorities. To me, that's politics as usual and more or less appropriate. But what I think the administration is doing is to view nonprofits through an ideological lens, screening out those parts of the sector it does not like. This is a direct threat to free association and the pluralism of private groups and the stifling of dissent. Universities have been an easy target as complex organizations, heavily dependent on federal funding, often a source of progressive ideas. It is easy for the administration to paint selected activities as socially harmful and demand institutional change upon threat of loss of millions, if not billions of dollars in unrelated funding. In some cases, the demands for change have included government supervision of internal operations and curriculum changes. These demands fly in the face of core principles not only of academic freedom, but also associational freedom. In fact, it brings to mind the attempted takeover of Dartmouth College back in the 19th century. The administration's willingness to follow through on funding cuts that most observers believe will harm science, public health, and American competitiveness with no bipartisan outcry illustrate that the political consensus that American higher education serves the public good is weak, if not gone. A similar leveraging of federal power over the internal affairs of private organizations is starting to manifest also in federal grant making. An executive order from early August outlines a new process for federal grants. The process requires that all discretionary grants be approved by political appointees of the president, who are to review grants to ensure that any granted funds, quote, demonstrably advance the president's policy priorities. No grant will be awarded if it will, quote, promote anti-American values. Examples of un-American activity include race-conscious affirmative action, even if lawful. The grant rules also announce that some viewpoints are un-American, namely the denial of the sex binary in humans. As one commentator noted, under this new process, political loyalty itself is being written into the rules. Even if, as I suspect, this part of the executive order won't survive a legal challenge, we already know that grantees are responding to these sorts of political litmus tests by changing the way they ask for money, if not their actual programs. Federal funding recipients make an easy target because the federal government has considerable constitutional authority to impose conditions on the use of funds. And to an important degree, we expect any elected administration to be selective about which organizations and programs it wants to fund. That just makes sense. But to the independent-minded, the very idea that grant applicants must demonstrably show allegiance to administration policy is chilling and, dare I say it, Orwellian. Further, the administration's approach is not limited to federal funding recipients. In another August initiative, this time a proposed regulation, the administration played a new card that has serious implications for charitable tax exemption. An existing federal program called the Public Service Loan Forgiveness Program provides that students may pay off their student loans by working for a public service employer, which under current rules includes any 501c3 organization, without making further policy judgments about the types of work the organization engages in. In other words, current law reflects the long-standing approach to 501c3 organizations as a generic standard for a public benefit organization. The new rule, however, proposes to deny qualified employer status to 501c3s that are engaged in activities with a substantially illegal purpose, meaning that graduates may not work for these C3s if they want the government benefit. On the surface, this may sound fine. Why should an organization with a substantial illegal purpose be considered a public service employer? But as always with the law, the details matter. The rule, the proposed rule, alludes to the illegal purpose doctrine of charity law, namely that a C3 cannot have an illegal purpose. Thus, under charity law, if, and I emphasize the if here, a 501c3 has an illegal purpose, it should lose its 501c3 status and therefore also lose eligibility under the loan forgiveness program. That, however, would require an IRS audit and be subject to judicial review. The proposed rule, thus, is an end run around normal tax exemption law. It effectively sidesteps the IRS, vesting the Secretary of Education with the power to determine whether an organization has an illegal purpose. In other words, even though a group is in good standing under 501c3, the administration can create favored and disfavored C3s under the loan program without any semblance of process. The administration is also being selective about which purposes to prosecute as illegal. Under the proposal, illegal purposes include providing what blue states would call gender-affirming care, and what red states and the proposed rule would call the chemical and surgical castration and mutilation of children. Other illegal purposes listed by the rule include the aiding and abetting of illegal discrimination or illegal immigration, all terms with uncertain dimensions. Thus, any 501c3 with a DEI program or that provides care for immigrants might have an illegal purpose under this rule. Why this new approach? The proposed rules say that the substantial illegal purpose test is necessary to protect taxpayers from funding loan forgiveness for individuals employed by organizations that operate in a manner harmful to the public good. But when 501c3 is the legal standard, that job is the IRS's and that of Congress. Further, many nonprofits engage in controversial activities where there are gray areas in illegal and legal activity. The proposed rule thus appears designed to stop organizations from engaging in any activity even tangentially related to a purpose it identifies as illegal. In short, what you see in the proposed rules is an effort to devalue and delegitimize certain activities of 501c3 organizations consistent with the administration's ideological and policy priorities. Further, if the rule takes effect, it is a mere baby step for the IRS then to rely on the regulation as a basis for denying exemption to organizations engaged in any of the activities identified in the proposed rule, all without any action by Congress. And even if the IRS does not act, the chilling effect on organizations fearful of losing their exemption would be and is real. The executive order from January that equates DEI with illegal discrimination is similar, as are non-binding guidelines from the Department of Justice about the types of DEI-related conduct the administration views as problematic. Although some administration anti-DEI initiatives have been put on hold for constitutional reasons, the intrusion into the internal affairs of nonprofits is real and concerning. One executive order, for example, has a section devoted to ending illegal discrimination in private organizations and identifies private foundations, universities, and large nonprofits as targets. The administration also encourages members of the public to inform on organizations that may be engaged in illegal discrimination using tip lines and public websites. As to what constitutes illegal discrimination, the vagueness is the threat. I have written about one case, the American Alliance for Equal Rights versus Fearless Fund, which I think is a tipping point in this area. There, a panel for the 11th Circuit said that a 501c3 charities grant program in favor of Black women-owned businesses violated a post-Civil War civil rights statute. This is an unprecedented interpretation of the law, and I think wrong. Nevertheless, in at least 3 states now, the affirmative use of race as part of a charitable program is arguably illegal discrimination. The implications are stark. The administration and private litigants can use the holding of the Fearless case, combined with the Harvard affirmative action decision Students for Fair Admissions, to argue that any affirmative use of race, even in the donative context, and even by purely private actors, is illegal. This includes scholarships, fellowship programs, grants, and might even extend to programmatic considerations like tutoring and counseling. Further, even in the absence of illegality, the administration's open hostility to certain activities and aggressive use of executive power raises the possibility that some groups will be targeted for loss of charitable status because they are engaged in activities that the administration deems contrary to fundamental public policy. This would be to take the Supreme Court's decision in Bob Jones University versus United States beyond its traditional confines of anti-Black discrimination in education. This doctrinal move has already been used successfully by the American Alliance for Equal Rights. The group filed a complaint with the IRS about the Gates Foundation's minority-based scholarship programs, asserting that the foundation should lose charitable status under the Bob Jones decision. The Gates Foundation backed down without a fight. And in a widely reported incident, as I mentioned earlier, President Trump suggested that Harvard should lose its tax-exempt status, presumably on Bob Jones-like grounds. Moving quickly to the legislative front, the big, beautiful bill taxes the large endowments of colleges and universities, and while the piggy banks of elite institutions make a nice target, the tax does not appear to be grounded in tax policy. There were no hearings, but rather is based on dislike of higher education and is an exercise of raw power, not representative government. Fortunately, 2 harmful provisions were stripped from the House-passed bill. One proposal would have taxed private foundations at steep rates, which, if enacted, would have been a straightforward redistribution of grant funds from charitable beneficiaries to the Treasury to pay for tax cuts. Another provision, known as the Nonprofit Killer Bill, would have vested the IRS with the authority to deem without an audit that a 501c3 organization supported terrorism and automatically suspend its tax-exempt status. This provision seems poised to come back, and if enacted, would give the government significant leverage over charities that engage in international affairs and even controversial domestic law issues. Finally, in ongoing litigation in Texas, the IRS has proposed a new interpretation of the Johnson Amendment for houses of worship. If this is a sign that the administration and eventually Congress intend to relax or abandon the rule that keeps charities nonpartisan, the political neutrality of the charitable sector will be forever lost, with hard-to-predict impacts on future grants, appropriations, and trust in communities. In short, in the first months of this administration, the message is that the work of nonprofits is wasteful, harmful, and not in the public interest, and there are clear signs that the administration is looking for ways to target nonprofits on ideological grounds. What concerns me most are the tactics that appear designed to intimidate private organizations into either chilling their speech and mission or attacks on the mission itself as illegitimate. If sustained, these attacks on nonprofits jeopardize the political consensus that all things equal, nonprofits are a force for good in society. And with two legs of the stool crumbling, the pluralistic civil society we have long enjoyed may falter. So what is to be done? First, there are some silver linings. Apart from the endowment tax, the big beautiful bill did not target charitable tax exemption in the ways that many feared. And also in that bill, Congress took a small step to shoring up the charitable deduction by passing a new deduction for non-itemizers. The fact that this revenue-losing provision passed shows that there is still interest in broad-based private philanthropy on the Hill. The optimist in me hopes that the now chaotic law on the charitable deduction can pave the way to an overall better charitable giving policy going forward, perhaps a unified charitable giving credit and reasonable distribution rules for DAFs. Second, some of the administration's more blatant efforts to chill nonprofits are being recognized in court as exactly that and have been put on hold due to First Amendment concerns. Third, strong resistance to relaxing the Johnson Amendment is, I believe, critical. If that rule is weakened or repealed, the political neutrality of all nonprofits is at risk, which will only further damage political support for a pluralistic nonprofit sector. Fourth, charities must know their rights. The administration cannot arbitrarily revoke tax exemption. There is a process. Some charities also need to be willing to take a stand and win in court and engage in peaceful protest when necessary. Charities are allowed to advocate for causes and speak on the issues and must not be shy in defending their missions and programs. Some charities should also begin to consider alternatives to federal funding to the extent feasible. Finally, nonprofits need to get Congress involved and explain how their work benefits people, creates employment, and fosters community, and rebut the deep state narrative. The burden ultimately is on the people and on their communities to defend pluralism and association and stand up for their values. The risks to charitable independence are real, but at the same time, we have centuries of law, history, and tradition on the side of pluralism and free association. Thank you very much. I'm happy to take any questions. Although maybe I ran out the clock.
We have about 5 minutes for questions if anybody has some.
Yes, sir.
Hi, so I have a question. So what is the policy for these institutions with billions of dollars of endowment, like colleges as opposed to hospitals, to have tax exemption on their earnings? Is it necessary to fit within your model that they don't pay taxes on their investment gains?
So that is a great question, and so that question is a tax policy question, right? So you're taking the excellent assessment of, well, gee, Harvard is really, really rich, It has endowments in the tens of billions. Does it really need to be sustained by tax exemption, or should we consider taxing its endowment, and if so, in what way and for what objective? Right? I think those are fair questions, and they're questions that I have had in my tax policy career as to whether large wealthy institutions continue to need tax exemption. So that's what I would put in as the norms within, let's have a tax policy debate, let's have hearings, let's discuss it. I think what we've seen with all of the endowment tax proposals was none of that discussion, right? We saw proposals to tax endowments at the corporate rate, above the corporate rate. The initial endowment tax that was enacted in 2017 piggybacked off of the investment income tax on private foundations, which itself has very little tax policy basis. I think what troubles me is that these rules are being written out of hostility to groups and not in a way to try to come up with a reasonable tax policy. But I grant there are debates to be had about how, whether, and when to tax endowments.
Thank you.
Yes, Paul.
So I've been struck by the fact that there are some institutions, and Harvard is the great example, that do a huge number of things, all under more or less one umbrella. And then you have a situation like in Cleveland, where you've got a score of institutions, some very good, some struggling, but many all with high ambitions, but they're all fragmented. Each one is smaller, therefore, and you have a cluster. One consequence of an attack on large endowments is to say, all right, Harvard should break up into its components. It's got 5 affiliated hospitals that are among the 20 biggest researchers in the world. Why don't we just make each of those separate? And those kinds of things. What do you think? Do you think there's implications in that direction?
So that's a tough one for me to answer, right? I mean, I think that Harvard is an anomalous example of everything, because they are the richest, they are the biggest, they are very successful, they're very important. Should the federal government decide that there are some antitrust concerns, or we need to break Harvard up, or I don't know the answer to that, right? I think in a way those are different questions from the ones that I'm focused on and that concern me, which, and sometimes the answer might be, well, our political process and our political system is broken. If we use the normal route, we're never going to get at the Harvards of the world. So we just have to use blunt force, and we just have to threaten to pull their exemption and penalize them. Again, I think that I don't think is what is driving this. But again, I guess I'm guessing about what the motives are.
I partly had in mind that you could pursue the same purposes, not from the government's point of view, but from the nonprofit's point of view, by redistributing into a larger number of units, each of which would be more difficult to focus.
Well, and I think that's where one of the planning opportunities from the endowment tax is that they're going to start splitting their endowment up into different pieces and different entities, and try to, of course, minimize the tax burden. So it'll become a conversation about tax planning as a response to it, to minimize their liability, for sure. So yeah,
Doesn't meet all the other things you were raising.
right. And I think to me, what's troubling about this moment are the attacks on the independence of private institutions. And I think at least with the endowment tax is one piece of it, but the federal funding cuts are another bigger piece, where it seems like those cuts are unrelated to the underlying violation, whether it's anti-Semitism or DEI, whatever happened there. One, there's not proof that there's been illegality, and two, the funding cuts aren't related to those programs, they're related to health and science. So it's just hard to make that make sense to me.
You one more question.
Yeah,
I think I saw his hand.
Yeah. So is your objection then one of process? In other words, if you actually sick the IRS on all of, of these 501c3s, et cetera, and came to the conclusion that there is illegal discrimination that is then validated by court process, I guess, would you have the same response that I'm hearing now?
So process is an important American value, right? So
For sure.
it's vital, and I think part of the process here, certainly for civil rights violations, is that there is a process for Title VI funding, which is not the IRS's business, right? So if there has been a civil rights violation, then you expect an investigation by DOJ. There would be some conclusion of illegality as to those violations, and then you could withdraw the federal funding. As to what spillover effects, if any, that has on tax exemption is another question. But part of what I certainly would like to see, and I think I've been an advocate for in the past, and I mentioned it a little bit in this talk, is a credible IRS. Part of the problem is there are real issues in large nonprofits, whether it be hospitals or large universities, that the IRS could and should be performing some audits to see if taxpayer funds are being used appropriately. Part of the difficulty is that the IRS has not been given license to do that since the Tea Party scandal. And it's quite interesting if you go back to literally almost the day before the Tea Party scandal broke. The person who was the public figure of that scandal, named Lois Lerner, who was the head of exempt organizations at the time, I think 2 days before, had been testifying before the House Oversight Subcommittee about the IRS's compliance program into colleges and universities. And there was some sort of effort to audit and perform regular oversight functions. All of that stopped after Citizens United. And it's just been a complete turnaround from what was going on before then, where there was at least some normalcy in terms of enforcement and give and take between the Congress and the IRS, and expectations. Senator Grassley was a very strong proponent of that sort of thing. That's completely stopped. And I think that's a problem. That's a real problem.
So I hate to cut off a good conversation, but there is a reception in the rotunda, the lower rotunda out there, if people want to ask questions afterwards, and I'll sort of push people that direction if you are thinking about diving down to the well of the room. But please join me in thanking Roger for a very awesome.
Thank you. Thank you very much.